Now, I am going to dictate a legal passage at the rate of 120 words per minute. 5, 4, 3, 2, 1. Let's start. This appeal by special leave calls in question the judgment and order dated 6th August 2019 of the High Court of Judicature at Bombay Bench at Nagpur, whereby criminal appeal number 211 of 2016 carried by the appellant assailing his conviction under section 302 Indian Penal Code 1860 within bracket for brevity IPC and sentence of life imprisonment with a fine of rupees 6,000 and a default sentence of 1 year as well as sentence of 7 years of rigorous imprisonment and fine of rupees 4,000 for the offence punishable under section 307 IPC was dismissed. The prosecution case was that Nandakishore within bracket for brevity, the victim, was murdered on 26 September 2013 at around 5 p.m. by the appellant. The other three victims, namely NK PW2, Vilas within bracket PW3 and KB within bracket PW4, received stab injuries caused by a knife also inflicted by the appellant para. A report was lodged soon thereafter by the mother of the victim Rekhabai within bracket PW1, leading to registration of an FIR under section 302 and 307 IPC. The postmortem report dated 27 September 2013 within bracket Exhibit 35 recorded stab injury to neck of the victim as the probable cause of death. Para. Consequent to the registration of the FIR, Police Inspector B. Thakre within bracket PW8 took up the investigation, visited the spot of the incident and prepared spot panchanama. He found the spot of the incident stained with blood and recovered a blood-stained knife, a wooden stick stained with blood, 3 pairs of chappals, 2 spectacles and a blue dot pen. PW8 arrested the appellant, and since he too had received injuries, he was referred to the Rural Hospital Katul for his medical examination. Para. Upon completion of the investigation, a charge sheet under section 302 and 307 IPC was filed before the concerned court against the appellant. Upon committal, charges for the above said offences were framed, to which the appellant pleaded not guilty and claimed to be tried. Para. The prosecution examined 8 witnesses to support of its case. None was examined on behalf of the defense. However, the appellant filed a written statement which we propose to refer to at a later part of this judgment. The additional sessions judge largely relied on the statements of PW2, PW3 and PW4 to convict the appellant. Para. The court concluded that the appellant committed the murder of the victim with a knife within bracket ART.1 and also attempted to commit the murder of PW2, PW3 and PW4. The defense of the appellant appeared to the court to be false, and the prosecution was held to have proved its case beyond reasonable doubt. This was followed by the convictions and sentences noted above. Para. The aforesaid judgment having been challenged before the High Court, the relevant division bench was of the view that the findings did not warrant any interference and that the appeal was devoid of any merit, hence it was dismissed. Para. The first limb of the arguments advanced by learned counsel for the appellant is that the courts below clearly aid in convicting the appellant. According to him, the following points deserve consideration. Stop. Thank you. Jai Hind, Jai Mirabai.